had been affected by the comments made since his first proposal. Thus, that being the case, I was in hopes that he would reduce spending by the $71 million that the Cabinet plan would have raised when the Attorney General junked it because of his question of constitutionality.
Mrs. Bodine, we are in receipt of your letter in which you generally discuss the matter of air pollution, specifically General Portland Cement Company. And in the case of due time, relative to Portland Cement, we are talking about Monday. We have been in contact on prior occasions and more recently within the last couple of days. Plant management, they have agreed voluntarily to cease operations Monday morning for an approximate period of 2 weeks in order to pursue further improvement of control measures which they have presently being used. Generally speaking, people, as you know, have shown greater concern within the past few years about the quality of our atmosphere. Specifically, the city of Dallas has adopted a cleaner air ordinance under which things like this are controlled. We have worked with these people at General Portland, and they have shown interest, I think, as witnessed by the fact that they have agreed to close down their plant to pursue the matter of control further. Hopefully, through later collection of air samples by which we determine concentrations, this situation will be further improved. We do appreciate your interest in this matter as other citizens in the city of Dallas, and would like for you to feel free to contact us at a later date if you feel there's anything else we might help you with on the matter.
With the great mass of cases and the tremendous load backlog in the criminal courts, we cannot depend on lawyers providing their own expense money and their own time to represent clients. And if we cannot depend on that, then we know that uncompensated lawyers or inadequately compensated lawyers will not be able to give them the kind of service and the kind of representation which meets the standards of adequate representation.
Now, does this mean that the Supreme Court would possibly overthrow the case if the attorney was not adequately compensated?
Yes, the Supreme Court has overturned cases where there's been no attorney under the Sixth Amendment, which guarantees the right to counsel. I'm suggesting that the Supreme Court would not find it difficult in the future, where it found that inadequate compensation was given to a lawyer appointed to a poor man, to find that this was just as bad as having no counsel at all. Because if counsel could not give the time and could not give the effort to give full representation to his client, the Sixth Amendment would be violated and the case would be reversed. Now, if the Supreme Court were to make that decision, then the county and the state governments would have no choice. They would either have to provide the funds to provide this adequate compensation or choose not to prosecute criminal defendants who cannot afford lawyers. We really mean the kind of compensation that a lawyer would make if he were to be retained in a private case. Now, we don't intend by that standard to try to equate the appointment of a lawyer in a case involving a poor man to the kind of fee that the top defense lawyer can make when he represents a very rich client. We're talking about a mean, adequate compensation.
Now, where is this money coming from?
Well, the money will have to come from local government, possibly, well, in federal cases, the Criminal Justice Act already provides funds on the basis of congressional appropriation. It is possible in the beginning that Congress might enact legislation and grant some aids to the states in order to allow the states to provide adequate compensation. But in the long run, the county and state governments are going to have to provide it.
What will happen if the county and state government does not provide this adequate compensation?
Well, my own personal prediction is that failure to provide adequate compensation to a lawyer will be interpreted